Hello and welcome back to the channel. Today we're going to talk about the CPS process in general. Just an overview of how a case starts and where it can end up. A CPS case begins when the department gets a report. A report could come from any number of sources. There are many professions that are mandatory reporters. If they have a reason to believe that a child may be being abused or neglected or anything like that, then they are required to report that to CPS. Police officers, teachers, medical professionals, a lot of these professions are obvious and obviously include attorneys as well. However, sometimes reports can come from family members, from neighbors, from lots of different places. Once the department gets in a report, it's assigned a priority level, and then an investigation starts from there. The priority level is probably what you would imagine. The more severe and more evidence there is of a abuse or neglect going on, the higher priority it's going to be. For example, let's say that a parent is arrested while drunk driving and has a child in the car. The police are going to arrest the parent and say they can't find another parent, the parent can't give them the name of relatives or friends or anybody else to take the child, and the child has nowhere to go. Well, obviously they're going to call CPS because there's no other choice. So some things are that obvious and to that certainty, and then at the other end of the spectrum they may be something that would not be considered neglect or abuse, may not get followed up on a whole lot, certainly not right away, but an investigator may reach out just to make sure there's not more to it, and if they conclude that that there's nothing to substantiate the claims, or if the claims made don't rise to the level of CPS needing to intervene, and they verify that, then they would just close out their case. So once investigation gets the report, that's what they do, is they start investigating. So they will talk to the parent, they may talk to relatives, they may talk to teachers. If it has to do with an incident that involved the police, they may reach out to the police department or the particular police officer. If there's allegations of drug use or domestic violence or things like that, then they may reach out to the police to see if there's a history of that among the parents or at the residence. They might look in their own records. Actually, they probably always look in their own records to make sure that there's not a history of CPS involvement, because sometimes CPS gets involved, they patch up the situation, they move on, but then something else happens and they have to re-engage. Once they've concluded their investigation, or most of the way through their investigation, they have some choices. Actually, before that, there's something called an order in aid of investigation, and the department can get an order from the court to allow them to enter a residence or otherwise be able to talk to a child if a parent is preventing that, and to get the child's medical records, or to have a child examined by a medical professional. If the parent or caregiver is not cooperative with them and they have enough reason to justify it, they can go to court and ask a judge to give them an order that will allow them to do that. We'll talk more about those in another class. Once they've investigated, if there's an issue there, but it doesn't rise to the level where CPS has to remove, and that can be for a number of reasons. It may be some neglect but not too serious, or it could be a little more serious, but they can put a plan in place to, let's say, have a relative or somebody else either in the home or have the children stay with a relative while they offer services to the parents. We'll talk a lot about services and what they can be later on, but that is another option. Now, if it does rise to the level of some serious abuse or neglect, or if there is no way they can come up with what they call a safety plan, like putting the children in either out of the home in with friends or relatives, or having somebody in the home to supervise while the parent does their services, then they may end up having to remove. In the situation I gave at the beginning, that's an obvious removal. If parent's being arrested and there's no other parent or caregiver or family or friend that can adequately take care of the child, so if you have like a friend or relative that has convictions for abusing a child or family violence or some type of violent crime or something, and they're probably not going to agree to leave the child there, especially the more recent the conviction is. But so if there's none of those options, then they'll go to a removal. What they do when they want to remove is they will file what's called a petition in the court. It's just like any other lawsuit. It always starts with a petition. And they have to attach an affidavit where the investigator will lay out their investigation, what they found, and why they believe that removal is necessary. Then there will be a hearing. It's not really a hearing, an ex parte hearing in front of the judge. Usually that's really just the judge reading the affidavit. Most of the time there's not actually a physical hearing. Actually, most of the time the judge won't even talk to the investigator. In a lot of these cases, it's not a close call on whether to remove or not. So, like in the example I gave before, once the judge has read what happened and seen that the department has tried to find other people to place the child with to avoid removing the child, the judge is probably going to go ahead and sign that order. However, the judge may reach out to the worker, or more likely to the attorney representing CPS, to speak to the worker or to get more information if they need to. Some judges actually have the workers' numbers programmed in their phone, and they'll call them up and say, "Wait a minute, explain this. I don't understand what you're saying here," or something like that. So there may be some actual interaction like you would have in a hearing. It's called ex parte because the other party, meaning the parents, are not there. It's very rare that you can have a hearing in our justice system without the other side having their chance to have a say. This is one of the few situations, and it applies when a child is in what they call an emergency situation, when the child is likely to be subject to abuse or neglect, or has been recently. And so this is one of those rare cases. It's followed up with the adversary hearing. In the rare situations where the government or anybody could have a hearing without the other side having their chance to say, there's going to be a hearing set very soon. And in the case of, in CPS cases, it's within 14 days. They have to have a hearing set so that everybody will come to court and the court can hear from all sides. Once again, we're going to talk about all these hearings and go into more detail with them, but this is just an overview. So after the adversary hearing, assuming that the court leaves the children or child in the care of the department, then the case moves forward. If they send the child home, case is probably over, or it'll be sent to orders to participate in services, which is another thing we'll talk about later, in another video, I mean. So if the case progresses forward, the next hearing, which will be within 60 days of the original removal, is called a status hearing. That hearing focuses on two main points. One is to make sure that the parents have been served. And being served means being formally notified that there is a case pending and given a copy of the petition and the affidavit. Usually by the status hearing, the parents will have their attorney involved, will have an attorney, and will receive all that through their attorney. The other thing for the status hearing is the service plans. So the department working with the parents is how it's supposed to be. It usually doesn't happen that way. So if you're a parent or if you're an attorney representing parents, you want to make sure that the parent does have some input on the service plan. The service plan is the list of services that the CPS worker thinks you need to help you get to a point where you can provide a safe and stable home for your children. I say the CPS worker, it's not just the worker, it's generally the worker and the supervisor. A lot of it is standard services they put in every or most of the service plans. For example, if there's an issue or history of drug abuse, then a drug assessment is going to be part of it. Parenting class is very common. If there's abuse or neglect, then a concern obviously is does the parent fully understand or have the skills necessary to parent properly, and some other things. So at the status hearing, the court will hear about the service plans, will hear from the sides and see if everybody agrees, or if not, why, and then we'll make the final service plan in order of the court. That's very important. We'll talk about that more at the status hearing, in the lecture about the status hearing. The next hearing, which will happen about 4 months, within 4 months of the status hearing, or 6 months after the initial removal, is the first permanency hearing. A permanency hearing is for the court to hear how the case is going, how the parents are doing on their services, how the child is doing. A lot of times the children in these cases, they need services as well. And so it could be medical, could be therapy, could be a number of things. They will actually have a service plan as well. And at the permanency hearing, the court's going to want to hear how they're doing in their plan as well. If the children need anything that they're not getting, or if the parents do, and how they're progressing in the case. Then 4 months after that is the next permanency hearing, or within 4 months. And same thing, it's just another update. However, that's getting close to the 1 year deadline. There's generally a 1 year deadline on how long these cases can last, with a couple of exceptions. There can be a one-time 6-month extension if necessary, and then we're going to talk about monitored returns, and that's another option. But the second permanency hearing, again, is kind of the same as the first, except that the second, the department by then or at the hearing may change their goal. So they start off with the goal of reunifying the parents and the children. And if the parents aren't progressing in their services, or aren't doing them, or continue to use drugs, or whatever the issue is, then at the second hearing, the permanency hearing, the department may announce that they're changing their goal to termination. And doesn't mean it's over. Doesn't mean a parent can't turn things around at that point and get the department to change their goal back. It usually doesn't happen that way, but it does. It does sometimes. But anyway, that's the time that the department makes it clear to the court and to the parents. They may have already told the parents or the parents' attorneys before then, but it's officially included in the report, and probably spoken about at the hearing. Now, if the parents are doing well around that time, or a little before, a little after, you might have what's called a monitored return. And that's when the department says, we're ready to return the children, or you and your attorney have gone to court and convinced the court that it's time to return the children home. But regardless, rather than sending the children home and just dismissing the case, the judge will send the children home, and they're still in the conservatorship, the managing conservatorship of the department, but they're placed in the parent's home. And the purpose here is to kind of have a trial run, if you will, or think of it as a probation, if you want, although that sounds kind of harsh. But CPS stays in the case, they monitor it. If the parent's doing anything that puts the children at risk, or if they're violating court orders or anything like that, they have the authority to remove the children. But otherwise, they monitor, see how it goes, continue to offer services if needed or new services if needed, help the parents to get the children get them daycare or medical appointments or things like that that they may need that can be provided while the children are in the care of the department. If all goes well, that can last as long as 6 months, really no longer. And at the end, the department would get out of the case and the managing conservatorship would be transferred back to the parents. So if things don't go well or if people aren't in agreement on it, you might have a final trial. And this could be a trial in front of a judge or a jury. It could be a trial to terminate the rights of the parents, one or both parents. Or it could be a trial just to award permanent managing conservatorship to the department or to another person. This can be a trial in front of the judge. This can be a trial in front of the jury. We will talk more about the final trial process also in another video. But at that point, several things could happen. The parents' rights could be terminated and the child put in the care of the department on a permanent managing conservatorship basis and made available for adoption. Or they could go home. The court could rule, no, we're not going to terminate your rights, and the children are going to go home. Or the court could say, we're not going to terminate your rights, but the children are staying in the department's care. So depending on how they rule, a number of things could happen. One option that's always available is an appeal. If the parents are unhappy with the decision, they can appeal to the Court of Appeals. It's a different process than going through trial, and it is not a do-over. But there is that option, and there'll be another video on appeals as well. Assuming that the parent's rights are terminated and the child's in the department's care, then the department works towards getting the child adopted. Now, the child could already be placed in a foster home or with a relative who wants to adopt. So if they had decided that they were going to work towards termination and to have these caregivers adopt, then they might have taken a few steps in the process already. There's not a whole lot they can do until termination is done, but what they can do, if it's that situation, they will facilitate, because the idea, of course, is to get a child adopted as quickly as possible, if that's the route that they're going down. Otherwise, they will start looking for, when the time is appropriate, looking for an adoption-motivated home for the child or children. Some children that come into the department's care, they have some severe behavioral issues. They could have medical issues, any number of things. And so sometimes they may need more help, therapy, things like that, before they would be ready for adoption. So in those cases where the parental rights are terminated, the goal, of course, is to get the child in a permanent home, an adoption home. And so at that point, they work towards adoption. Now, that's just a quick overview. There's so much more to each one of those steps. So look at the videos that focus on those particular hearings and steps, and I will have more detail in those. Thanks for tuning in. I hope you have a great day, and I will see you soon.